Good morning. The hearing board is in session. Today is Thursday, March 9th, 2017. We're meeting in the hearing room at SCAQMD headquarters in Diamond Bar, and the time is 9 a.m. We have one matter this morning, and that is SCAQMD versus Aircraft Heat Treating Company, Inc., case 6066-1. A motion to appeal. Who's representing Aircraft this morning?
Good morning, Mr. Camarena. Ed Duckers from Stoll Reeves on behalf of Aerocraft, and I'm joined here at council table by Ivan Tether and Peter Surrier, who's in-house lawyer with the client.
Thank you. And the spelling of your name, sir?
D-U-C-K-E-R-S.
Duckers.
Yes, sir.
Okay, and representing executive officer?
William Wong on behalf of the executive officer.
Okay. Are there going to be any witnesses today?
Not on the issue of whether the board has jurisdiction to hear this appeal. If the board finds that it has jurisdiction and is prepared to move to the appeal, then yes, we do have witnesses.
Yes, and that will be the case. If we do find that there is jurisdiction, we will then immediately move to consider the appeal. Okay, what we're going to do is take some time to read the material. The documents that were requested by the end of the day on Tuesday, the one from the district was received by the board members by email on Tuesday evening, and then the one from Aircraft, apparently they did submit it late Tuesday evening, and it was emailed out to the board members on Wednesday morning.
Mr. Chairman, it was submitted at 4:18, approximately p.m. on Tuesday afternoon, and read by the clerk of the board at 4:35 p.m.
Okay,
Thank you. Just clarifying that.
appreciate that. But we didn't get it until the next morning, and so we had time to read them. There is yet another document. That's the authorities in support of the district's brief. Rather thick document in, I think it's in English, and that, although it was filed on timely, wasn't, for some reason, the board members did not get it until this morning. So, and
Those are simply the cases that we cited. I think pursuant to one of your rules, you would like copies of the cases, so we do that. And we do wonder whether all that legalese is really English, but you may proceed.
okay.
Mr. Chairman, we were not served by the district with that document, so we haven't had a chance to see it.
Ms. Broussard?
The document is merely the authorities and cases that are cited in the brief, because this hearing board does not have access to Westlaw or Lexis to get them ourselves.
Okay, that's fine.
Okay. Senator?
Chairman, on the amended findings and decision for an order for abatement, this was dated December 14th, 15th, and 16th, and it doesn't show that I was present. I was, in fact, present for the 14th, 15th, and the 16th was on a Friday, I believe, but I heard it on webcast. That should be noted.
Were you here on Friday?
I was not here on Friday, but on the 14th and 15th, I was here.
Okay. And does it show that?
No, it doesn't show that.
Okay. That'll be corrected.
Thank you.
Thank you. Madam Clerk, would you see that the corrections are made?
We're talking about February 14th?
No,
This was December 14 and 15. We had hearings on this matter December 14, 15, and 16. The senator was here on the first 2 days, December 14 and 15, and that is not reflected on the minute order. Okay, what we're going to do is go off the record to give the board members some additional time to review the documents. Ms. Prusak, how much time do you think you'll need?
Well, I don't know if the others have read the
Well,
briefs and what
they,
I need about 15 minutes.
yeah, except for the authorities, I think the board members have had the documents at least 24 hours and should be familiar with them, but we'll take,
So 15 minutes.
okay. Let's go off the right, we'll reconvene at, let's make it 9:25. Thank you. We're back on the record. Board members, have you had sufficient opportunity to review the documents?
Never, but we should proceed.
Okay, we'll proceed. Mr. Drucker,
Yes, Mr. Chairman.
you may make an oral argument if you wish.
Thank you, sir. I'll be very brief. I think we laid out the arguments well in our papers. It's based, of course, on the broad grant of authority that the legislature has given to this hearing board with respect to any orders of curtailment or abatement. You retain jurisdiction over those. You recognize that in this particular order of abatement, in which the board retains jurisdiction over this matter through the end of December 2018. And in paragraph 2 of the order specifically instructs the district that it must consider the evidence that Aerocraft presents with respect to emissions at the facility, and indicates that the district's determination is appealable. I think the clear inference in that order, although it doesn't say appealable to whom, the clear inference is that it's appealable to this board, and that was contemplated by this board when you entered that order. Despite the references in the district's brief to really irrelevant provisions of law, they haven't been able to point this board to anything that says it does not have authority to consider appeals from an order such as this, which is an order of abatement. So we think the jurisdictional argument is clear. I would particularly draw the panel's attention to the argument at paragraph C of our brief on page 6, because I think that is really the most compelling point. You know, what we're talking about here and what we're appealing from is a curtailment order that shut Aerocraft down and put its 51 employees out of work for a week based on a monitor reading that was plainly erroneous. And that's what we're appealing from, and that's what we're seeking to appear before the court or before the board on today. In order for that sort of order to issue, an order for abatement under District Rule 806, the closing cannot be made without a corresponding benefit to reducing air contaminants, and that simply doesn't exist here, and we need this board to take that into consideration on this appeal. The delegation of authority by the legislature cannot be handed off to other entities unless expressly authorized by statute, and we've provided you with the legal authority for that proposition. You can delegate ministerial tasks, which is what has been done in the abatement order, the ministerial task of collecting the monitoring data and evaluating it, and then fully and meaningfully considering Aerocraft's contrary data has been delegated to the district. But the board cannot delegate without possibility of review the ultimate decision of whether a facility subject to an order for abatement has to be shut down. That would be an impermissible delegation of authority. And what the district is essentially asking you to do today is to give them unfettered discretion in this circumstance to do whatever they want with this order of abatement without supervision by the board. And I do not believe there's any legal authority for that proposition. Thank you.
Mr. Wong.
Thank you, Mr. Chair and hearing board members. The district have filed a brief at the chairman's direction on the jurisdiction of this board to hear this appeal. And based on that brief, I assume we're moving to dismiss this appeal based on lack of jurisdiction. This motion is based on two major points. The first point being that the hearing board is a body of limited jurisdiction and has not been granted authority to hear this type of appeal. The second point is that Aerocraft is judicially stopped from arguing the hearing board has standing to provide it the administrative relief it seeks on its appeal. As to the first point, again, under well-established law, the hearing board as a limited body of jurisdiction only has the power granted by state law. Aerocraft essentially agrees with this conclusion. In fact, in its concluding statement says the same. It basically says the district cannot give it authority, but The legislature is the only one that give the hearing board that authority. The question then is, what did state law grant the hearing board authority with respect to appeals? Aircraft ignores the three provisions of state law that expressly deal with this point. Those are sections 42302, 42302.1, and 40713. Those provisions essentially provide the hearing board with authority to hold a hearing based on permit issuances, denials, or ERC refusals. Now, rather than look where state law expressly deals with appeals, Aircraft suggests state law gives the hearing board jurisdiction over this appeal in more oblique ways. First, Aircraft suggests the parties stipulated to such jurisdiction in this order. While the order, as Aircraft concedes, is silent as to who the appeal is to, the case law is clear that parties cannot stipulate to give the hearing board jurisdiction that it does not have. In any event, as we know, the hearing board, due to noticing requirements, really is unable to give Aircraft the immediate relief it seeks and has already sought in court. Aircraft also argues that the hearing board has implied authority to interpret and enforce the terms of its OA as a result of the authority the state law gives to issue OAs, orders for abatement. The district does not quarrel with the ability of the hearing board to interpret its own order. But clearly, the hearing board has no authority to enforce the terms of its order for abatement. In the case cited by Aircraft for this theory of implied power, and that is Martinez v. Combs, what it states is that the only authority you imply needs to be deemed necessary to the due and efficient exercise of the powers expressly granted to the board. Here, the hearing of this appeal is not necessary for the efficient exercise of hearing board's power to issue orders for abatement. Aircraft also makes the suggestion that the task that the hearing board has delegated is purely ministerial to the hearing board, to the district. On the contrary, ministerial tasks would simply be collecting the readings, saying it exceeds 1.0 and curtailing them. Rather, the district actually goes through extensive quality assurance and quality control checks on the data, determines whether they are valid or not based upon those quality assurance checks, and then actually subtracts background levels of hexchrome and other potential contributors to essentially determine whether Aircraft has contributed to an exceedance of 1.0 nanograms per cubic meter of hexchrome. So it's simply not ministerial. Aircraft also cites state law affecting variances, which are simply inapplicable to the power of the hearing board over these types of appeals. Finally, Aircraft argues that that hearing board is required to hear this appeal because of a required Rule 806A3 finding the hearing board needs to make regarding a corresponding benefit to air as a result of closure. Of course, we believe that finding can be made, but nevertheless, there are other 3 points. As the hearing board concluded in its order, this order for abatement was not based on 802A, but merely based on 802B, which is basically based on a stipulation of the parties, and no such finding needs to be made. And frankly, making findings has nothing to do with state law giving authority to the hearing board to hear this type of appeal. Ultimately, Aircraft argues in its brief at page 5, lines 16 through 17, that there's nothing that suggests that the hearing board lacks authority to consider this instant appeal. That, however, the district maintains is simply no standard for determining jurisdiction. Since, for example, there's nothing that suggests the hearing board can't hear appeals of CEQA or civil penalty determinations, which this hearing board has decided it has no jurisdiction to hear over. Finally, as to the second point, judicial estoppel. That doctrine applies to prevent litigants from gaming the judicial system, including this quasi-judicial system, by taking inconsistent positions. Aircraft has already taken the position that there is no administrative relief before this hearing board, as it has filed and pursued a lawsuit against the district on this same matter. The district agrees that there is no administrative relief, and aircraft should be stopped from arguing otherwise. That concludes the district's opening.
Board members, questions for counsel for either party? Mr. Wong, you told us that the parties cannot, by stipulation, give jurisdiction to the hearing board, which does not already have. We recently completed a case in Southern California Gas Company, wherein the hearing board, in a stipulated order, required Southern California Gas Company to pay reasonable costs for a health study. How's that different?
Are you saying the hearing board, suggesting the hearing board had no authority to do that, or I don't really?
Well, apparently we did. Maybe Ms. Prusek can help me.
I think the difference is what Mr. Wong is arguing is that we do not have a right to confer jurisdiction upon ourselves where no jurisdiction exists. So in this case, the argument is, do we or are we not granted the ability to hear this kind of appeal as under the Health and Safety Code? And one side says yes, the other side says no. But that question is inherently different as to whether or not in a stipulated order for abatement, we can require through stipulation a party to do something that they wouldn't otherwise be required to do under the rules and regulation. That's different as to whether we have the inherent subject matter jurisdiction to hear an appeal. I don't know if that makes sense, but they are different.
That they are different, and we agree with Ms. Prusek's analysis that the hearing board certainly has the right to impose conditions in an order for abatement. The question here is whether the hearing board has jurisdiction to hear an appeal of a determination under the order for abatement.
Mr. Druckers, you have a comment on that? No?
I would just say, I believe that the board does have the jurisdiction to administer its own orders and to hear appeals and to do what is necessary to administer its own orders. The district is putting an awful lot of weight on the word appeal and whether it appears in statutes. This is just administration of your orders and the exercise of your duties, which you clearly have jurisdiction to engage in. So much so that in the stipulated order of abatement that we're considering here, the hearings board retained jurisdiction and authorized appeals from district determinations that failed to consider our evidence. I believe that's what the board contemplated when it entered this order, and it's correct.
Thank you. Doctor?
This is a naive question by a physician. You two, both parties stipulated to this. You stipulated to the words may be appealed. Why didn't you, at that point, say, we can't do this?
Well, one point is that it doesn't say who the appeal is to. If it was said to the hearing board, we would certainly raise that objection. But let me point out that the relief they seek is somewhat of an immediate type of relief. So, for example, on the last curtailment, they sought an ex parte relief essentially on several hours' notice to get relief. They cannot do that with this hearing board. The hearing board is required to give 10 days' notice. So any relief that they seek can't be achieved until well after curtailment is over. So we did not contemplate, at least the district did not contemplate, appeals to the hearing board.
Could I speak to Dr. Lerner's question?
You may.
Thank you, Mr. Chairman. I'm sorry. You may or may not agree with this, but as a sort of a lawyerly approach to this order, you're asking if you said appeal, why did you agree to that if you didn't agree that it was appealable here? And Mr. Wong's response was, well, it doesn't say who it's appealable to. There's a principle of law that you have to take an order like this and read it in its entirety. And so when you read that this board is maintaining jurisdiction until the end of 2018 and the order is appealable, the clear way you have to construe the order is that the parties have agreed it's appealable to this board. I also would note in that regard that in the order, in the amended order, you instructed us to come back on March 16th, a week from now, which we're planning to do, to determine what changes or modifications might be necessary to the order. So it was also in the board's mind at the time that we entered into this that we would be back revisiting these precise sorts of issues. What has happened is that in the interim, since then, the district has simply disregarded its obligations to consider the evidence that we've presented, that it's relying on faulty data and making bad decisions both for us and for the community by relying on bad data to enter curtailment orders. And that's what we're here to appeal today.
If I may briefly respond, the point that council raises really kind of explains really the extended jurisdiction of the hearing board. I mean, this is a typical requirement, and it is used in case the order for abatement does need to be changed, and we are setting a hearing next week for that. In addition to their arguments about the district ignoring their data and not considering their evidence, actually, they did have a hearing in court, and the court did not find that to be adequate, and so denied the ex parte.
That is inaccurate, Your Honor. And I need to make this clarification. The TRO that we sought last week was based on the March 2nd curtailment. We are here appealing the March 14th curtailment. It's a different issue.
Okay.
February 14th, and the evidence will show, if we're allowed to put it on.
We're here to determine whether or not, at this point, we're here to determine whether or not this board has authority to hear the appeal. Let's stay on that. Ms. Prusak and then Senator.
But I think it is relevant, if you can just explain it. Are you saying that, so today you are appealing the February 14th, that was not the determination that you sought a restraining order or a TRO for in Superior Court?
That's correct.
And it was a different issue?
It was a different issue. I mean, at some extent, it traces back to the same problem, which is inaccurate data and failure to consider contrary evidence, but it was a different testing date and a different curtailment. So that the TRO related to the March 2nd curtailment.
Let me ask you, why did you, for that curtailment, go directly to Superior Court rather than exhausting your remedies here?
We had no choice. I mean, the board had told us you would not consider these things on an ex parte basis. And it was also on a Friday. I don't think the board sits on Friday. We were looking at a shutdown on Friday, Saturday, Sunday, at least 3 days, and Monday, 4 days of laying off our employees. So we did what we could do and had to do to try to get some relief.
Do you think, it sounds to me like the argument you're making right now for why you did not in the first place seek to exhaust remedies for the second curtailment is because it's futile to come before this board. Is that correct?
In that circumstance, it was.
Okay. Do you think that speaks to reading this, our order for abatement that was stipulated with regard to may be appealed, who it may be appealed to? And the reason why I ask that is because in all cases where there's curtailment, there is an immediacy to a decision on that. And this board can never hear it on an ex parte basis. So would you agree that it is always futile to attempt to come to this board first with regard to the issues of excluding data?
I don't know that it's always futile. For example, in this case, we still have an interest in having an appeal of this order heard because it does ongoing harm, even though it's been lifted, the February 14th abatement order. It does ongoing harm to the client. So we have to bring that here now. And if we were to run in now to court on this issue, I'm sure Mr. Wong would be there saying, you haven't exhausted your administrative remedies by seeking an appeal from the hearings board. So it's a little bit of a messy situation. You are right, because the hearing board does not hear matters ex parte. We cannot come in, we understand that, and seek immediate relief from a curtailment order. But we can still ask for relief on appeal from the decision that was made.
What about the the argument that was made by the district? If this hearing board agrees that it does not have jurisdiction generally to hear an appeal of this nature, of a dispute between a facility and the district where the district makes a decision within just the bounds of its everyday duties, which we do not hear those kinds of appeals. What about the legal argument that in a stipulated order for abatement, the parties cannot agree, and nor can this hearing board confer upon itself jurisdiction to hear such a matter simply because it's stated in a stipulated order for abatement?
It's a general rule, jurisdiction either exists or it doesn't, and you can't stipulate and agree to it. We believe, for the legal arguments we've laid out, that the jurisdiction plainly exists for this hearing board to administer this order, which is what we're talking about. We point to the order because we believe that evidence is a recognition on the part, at the time the order was entered, of both the district and my client and the board, that it does have jurisdiction to hear these sorts of appeals. Otherwise, that language would not be in there.
Which language? The may be appealed?
May be appealed. You can always appeal, right? You wouldn't put that in the order unless you were referring to the board, that you can appeal a decision and take it to court. And in fact, as I now think about it, as a lawyer, that's not even the right word to use. If we were to take them to court as we did, we would file a complaint for a declaratory injunctive relief, or we would seek a writ of mandate. We wouldn't be taking an appeal. So it is the use of the word appeal as opposed to the words that would be used if you were talking about going to court that also suggests that it was the intent of the board, the intent of the district, and the intent of Aerocraft that you have the right to hear appeals from the district's refusal to consider our evidence.
I don't have any other questions.
Senator.
Right, thank you, sir. Read both of the briefs from a lay point of view, and I understand that the problems are the same issues for the different dates: excessive emission of chromium-6, and you went to court for one hearing. The court's position, as I understand it, that you did not exhaust the administrative hearing. And therefore, that's why it's back before us. This is administrative. Now, Mr. Wong, you're the attorney for record for this district, and you sat there and allowed us to include in the abatement order an appeal. To whom, in my view, we're here to resolve problems, to eliminate chromium-6 being emitted in the atmosphere, not create more problems where that issue is not addressed properly in a timely fashion. As a layperson, it makes no sense to me. If this, based on the arguments presented by the respondents, they sure a lot of case law as to why this board should, not just implied, but should hear the appeal and then move on with the case of whether or not they're in violation. Move on with the case as to whether or not they're in violation based on evidence that the district provide to this hearing board. I think we're going up a tree backwards on this one. You want to respond, be my guest.
Thank you, Senator Holden. As I pointed out, the order itself does not say who the appeal is to, and therefore you have to construe the order in light of the authority of the hearing board. The parties can't give the hearing board jurisdiction that it does not have. And I agree, it would be nice if the hearing board can hear this appeal, because certainly the district thinks it's a good idea in that sense. But unfortunately, regardless of whether we think it's a good idea or not, you are limited by state law. And state law does not provide you the authority to hear this appeal. Of course, you can try to seek change in state law, but the state law is fairly clear that you only have the ability to hear appeals over permits, issuances, denials, and ERCs. That's all. And I think that is probably a reflection that the executive officer just makes hundreds of determinations on a regular basis, and to have the hearing board be the arbiter of all those determinations will essentially mean the hearing board will be busy constantly trying to resolve these determinations.
And Mr. Wong, you, the attorney for record, you permitted or authorized or stipulated to allowing the appeal to be included in the order of abatement. You did that. You sat there and watched it happen.
Yes.
Not knowing, not clarifying to whom the appeal would be made to whom or to who the appeal would be made to. And that just puts another clod over what we do here.
Yes, Mr. Holden, it was just not me. The other aircraft also stipulated
I
that.
understand that.
And it was unclear as to who the appeal is to. And I think you do need to look to state law to determine who the appeal can possibly be to. If it can't be to the hearing board, it must be to court. And frankly, the aircraft has exercised its right to go to court and seek, the immediate relief that they cannot get from the hearing board.
Is it not true that the court said, go back and exhaust your administrative hearings?
No, the court did not say
What did the
that.
court say then in that regard?
Well, I wasn't there at the court, but
I read the argument where it says exhaust your administrative hearing.
the argument, yes. And the reason why I put that in there is because in order to file a lawsuit in court, you first need to exhaust your administrative remedies. Aircraft obviously did not do so. It did not wait for this hearing board's ruling that says, well, we have no jurisdiction, go to court. It simply filed a lawsuit and then pursued the lawsuit on an ex parte basis. So basically, they took the position that there's no administrative relief to be sought.
Our common goal and objective, correct me if I'm wrong, is to require the respondents, or those who they represent, to clean up our air, reduce emission, right? Not to, if we go with you, then every stipulated order that we agree to, they can say the same thing and tie us all up. Then what are we to do here then? If our counsel is allowing to sit there and allow this to happen.
Senator Holland, the purpose of the order for abatement is so that the district itself can enforce the terms of the stipulated order for abatement. That's why we come and seek the order for abatement, so that the district can enforce the terms. In fact, there is a fairly significant penalty stated in state law for violating orders for abatement, and that's what the district threatens potential violators of orders for abatement with. So the district is the one that actually enforces these orders. It is not the hearing board. The hearing board does not go and inspect and cite for violations of the abatement order.
But you were giving us case law, and the respondents are giving us case law. And it goes up on appeal, the appellate court will listen. Now, on page 3 of your brief, line 13, and as a layperson, so you cite some general statements, but you don't cite any citations omitted. What do you mean by omitted?
No. The court quoted another case, and we just, rather than repeat those cases, we omitted those citations. But the main case is, we cited the main case.
Ms. Byrd?
I have a few questions. They're kind of, things are kind of roundabout for me. One is and I forgot your name, I'm sorry. Mr.
It's
Duckers?
Duckers, yes.
Okay, Mr. Duckers. Okay, that's what I thought, but I didn't want to say the wrong thing. Okay, so what you state in your brief on page 4, Section B, is the legislative grant of authority to the hearing board. And when I look in the Health and Safety Code under 40501, it's under Article 7, which is specific to variances and permits, neither of which we're talking about today. And I'm just wondering how, and one part of what is stated in Section 40501 is somewhere beginning on line 7, the hearing board shall have the powers and duties vested in the hearing board of a county district, and then it says, except as modified in this article. And this article is Article 7, which is variances and permits, which doesn't speak to orders for abatement at all. This is me as a non-lay person, just following the California Health and Safety Code. So how do you justify that as something that we would follow under an order for abatement?
Yes, Your Honor, you sort of, or excuse me, Ms. Byrd, you really have to flow from the argument in B to C. I mean, B talks about the grant of authority, broad grant of authority under, in Section 7 under 40501. But the orders of abatement gives that in Health and Safety Code Section 42451 delegates the ultimate authority to the board, which is the authority to shut or curtail a facility, and imposes the circumstances in which that can be done. That's what we're ultimately dealing with here, both in this order of abatement and in the finding that the district made. And it's our argument that you have the because it is your responsibility to make those ultimate decisions about curtailment or abatement, you retain inherently the jurisdiction to exercise that authority. You can't, and in fact, in the cases we cite, it would be unlawful to delegate that to the district. And it is a ministerial task, even though they may do QA, QC procedures. It is simply administering your order.
I'm sorry. And this is my understanding, and I've got to reach whatever it is. For me, Article 7 is specific to variances and permits. And while you're stating that there's a flow, I could accept more if you had stated specifically our jurisdiction as it in a more general way than if you had, specifically cited Article 7, which is under variances and permits. But that's my feeling on that. And then the other thing that I had, question I had to do with the reason that you would, why would you consider it to be an appeal to the board that needed to be made in the order if the board, in fact, cannot hear immediately any appeal that would come before it? Why would you consider that statement to apply to an appeal to this hearing board?
Ms. Byrd, I wasn't here for entry of that order, but I suspect I know what happened. It wasn't, at the time that language was entered into, it was contemplated that the appeal to the board would be immediate. There wasn't a recognition at that point in time that ex parte relief in the form of appeal wouldn't be available. So that's why you have that in there. But I want to go back to the fact that the order, which everyone in this room agreed to, uses the word appeal. And the more I think about that, the more I realize that appeal cannot mean anything other than to this board, because appeal is not the correct word to describe going to court, as I mentioned before. So it's clear that everyone here contemplated that the appeal would be taken to this board, and this board reserved jurisdiction for that purpose.
I'd have to disagree with that, that would be automatic just because it says appeal, that everyone would have that understanding that it would be to this board, because I don't believe I had that understanding, because I knew that you couldn't get an appeal to this board in less than 10 days. And with that, with my knowledge of that, I certainly wouldn't have thought that you would be expecting to have an ex parte appeal, because we don't do ex parte appeals. And then I guess my other question has to do with why would you be appealing, and I didn't completely understand in reading the briefs, why would you be appealing the February 14th when it's already done, you were shut down for that period of time? Is that just from this point forward, to make a record and this is how it works? Or why would you appeal that at this point?
There are really two reasons for that. The first is although it happened, it's now on our record, and it's something that people can point to in other circumstances and use against us adversely. And so we seek to have that removed. It is an ongoing and continuing harm to Aerocraft. There's really three aspects. The second aspect is, and this is troublesome, that because these decisions are being made on the basis of bad data from inappropriate monitors, it's impacting the ability of the facility to operate. It can't figure out what it should be doing because we get these random spikes on monitor 8 that don't correlate with anything else, and then that ends up with the facility being shut down. There's also an aspect of this that causes us to bring the appeal, and this goes to the timing again, because there's not ex parte relief, but this is a pattern of conduct by the district that, in a constitutional law context, they describe as capable of repetition yet evading review. And what that means is you can have the same repetitive conduct, but then it gets fixed before the reviewing body ever comes in and has a chance to say, stop doing that. And so there is an aspect of that compels us to pursue this appeal, because we want to ultimately, arrive at a process and procedure where the rights we were guaranteed under this order are being extended to us, and correct decisions are being made both for us and for the community.
Okay, understandable. Okay, then I have maybe one last question, and that is, you make reference to Section 40501. Are you making reference to any other portions of the Health and Safety Code or rules of the district that would give the hearing board jurisdiction in this matter?
Rule 806, which I mentioned earlier. And let me just check with Mr. Tether for a moment, if I might.
We're off the record.
Right, it's 42451 and Rule 806.
Okay,
And
425. I'm sorry,
42451.
451. Okay, of the Health and Safety Code, and then Rule 806 of the district.
Right.
And in Rule 806, can you point to the specifics as to what you are considering when you say that the hearing board has jurisdiction?
It's at 3, where it says that if the order of abatement results in the closing or elimination of an otherwise lawful business, such closing would not be without a corresponding benefit to reducing air contaminants.
And you're saying that because the hearing board has to make that finding, that's in this particular case, that's why you say we have the jurisdiction?
Yes.
Okay.
Why in this particular case? It's a stipulated order that applies to contested orders, does it not?
It says no order for abatement shall be granted. It doesn't limit it to contested or stipulated.
But
Have you-
Section B
Right.
addresses stipulated, not Section A.
Okay.
Okay,
Ms.
so,
Brissette? Oh,
I'm sorry, so does that mean no for 806? I just want to be sure.
Yes.
Okay, and so you're basing this on two, then, portions of the Health and Safety Code, 42451 and 40501.
Yes.
Okay, thank you.
Ms. Brissette?
Well, that was my main question, but you were not present for the actual entrance of the order and the hearing that we had on this order, were you?
I was not.
Have you reviewed the transcript or, I'm sorry, the hearing? Have you reviewed it?
I can't say that I've reviewed a transcript. I don't know that we have one, but I have consulted with my colleagues extensively who were here.
My recollection, and were you aware that at the time, questions were asked with regard to this particular portion of the order? And with this particular portion, I'm referring to the allowance in it for aircraft to have its own monitor and the requirement to consider any data from that by the district. Are you aware that there were questions asked with regard to concerns or concerns raised with regard to that particular provision, and in particular, concerns that the district actually be in charge of the monitoring? Were you aware that concerns were raised?
I cannot answer that because I wasn't here for that hearing. Mr. Tether was here, and perhaps it would be better if he spoke to that.
I would think, I do not specifically remember that, although I was here. However, I would think that the raising of questions and yet the persistence of the requirement that the district consider contrary data to the district's findings, or to monitor aid in this instance, would more support our position than oppose it.
My specific recollection was that the concern was that there was a requirement, or that meant that the district would have to supplant its own monitoring results with that of the monitor, if a monitor were used by aircraft, and that specifically those concerns were allayed by a recognition by the parties that in fact it's a requirement to consider, but not necessarily to take that on. Do you recall that?
Well, I think your wording supplant would overstate our position. We're not saying that the district has to throw out its data, but only that it has to also consider our evidence in reaching a decision whether the data calls for a curtailment.
When asked what specifically this board can do, why so late? If it's a February 14th, the curtailment already occurred, it already is over. One of the answers was, I understood to be so that there's something in place for, I don't recall exactly the wording that Mr. Ducker's used, but to have some kind of system in place for this decision to be made. And it was are you asking for, if this appeal were to be heard, would you be asking for it this late because you want this board to command the district to consider in place of its own data, your data?
No, no, I mean, we're not, there is a space between supplant, you have to take our data, and don't consider our data at all. But within that space, and certainly what we contemplated at the time, was that we were going to receive accurate and fair monitoring and appropriate and serious consideration of evidence suggesting that anomalous monitoring results were in fact anomalous. That hasn't happened. And that's what we ultimately, if not today, perhaps it's going to be next Thursday, may be speaking with the hearing board about trying to flesh out further.
Okay, thank you. I don't have any other questions.
Any further questions?
I have one. And my recollection of the hearing and including this portion in the order of aircraft being able to do monitoring was really something that the parties agreed to and not necessarily required by the district. And if you can, either of you can, Mr. Wong.
You're correct, Ms. Byrd. Initially, aircraft actually didn't want to do monitoring, but they, at the last minute, decided they wanted to possibly do monitoring. So there's nothing wrong with them doing monitoring, but the board is obviously concerned, as we are, that the district doesn't accept their results. The district relies on its monitored results. I do want to correct a misimpression, and it kind of goes to the merits, and I just want to correct a misimpression.
Can I just interrupt you for just a second before you go on, because
Sure.
I'll forget. Is it then your statement that the district does not require or would not have required on its own that this facility monitor?
Right, the district
Right, so that was only included.
would not have required,
Okay.
right, it's only included at their insistence.
Okay, okay.
But again, and Mr. Ducker has been claiming incorrectly that the district didn't consider their evidence at all. That's totally incorrect. In fact, we attached the declaration for the third curtailment, actually, and the facts are similar. They're basically relying on the same situation as for the second curtailment, that the district did consider it, and the court found that the district did consider the evidence.
That's not accurate. The court, we were in seeking the extraordinary relief of a temporary restraining order where you have to show a substantial likelihood of the merits. They came in with a declaration that said we considered it, and the court simply said, I can't make the extraordinary finding if they say they considered it. Part of the showing here today would be to examine the extent to which they considered it on February 14th. They gave it 16 minutes of consideration and an anomalous result, and declined to consider evidence that I think would lead anyone on the hearing board and in this room to the conclusion that it shouldn't have been basing a shutdown decision. But that's a different issue. Let me.
I think we're getting into the case, and I probably strayed off a little bit.
That's
and I may
okay.
have- actually, it's not.
Can I just speak briefly to your question, which was about the order? And the order is permissive as to whether or not Aerocraft can do its own monitoring or collect its own data, and also permissive as to other credible sources of information. It's not just Aerocraft sources, it's other credible sources of information that would be presented to the district, and in fact, that's what we've done. It's permissive in that sense. It's mandatory in the sense that the board or the district has to consider it. It says it shall consider that evidence in concluding. And certainly, I think the word consider has to be meaningful consideration. Otherwise, it's illusionary if we're not getting serious consideration, which we don't believe we are.
Thank you.
Senator.
On your 4, line 17, starting with 16.
Excuse me, Mr. Senator Holden, page 4, which brief are you talking about?
Oh, the respondents, aircraft.
Okay, thank you.
On page 4, starting with line 16, the board has all powers necessary to carry out this directive, which includes, of course, the power to interpret and enforce terms of the abatement order. That goes right to as long as we have jurisdiction. And then you cite the case. You said, recognizing that the authority of an administrative board or officer to adopt reasonable rules and regulations which are deemed necessary to the due and efficient exercise of power, the authority is implied.
Yes.
You want to comment on that?
I agree with that, Senator, and you know, this is our brief.
Right.
I think we all know, you probably better than most, that when the legislature makes enactments, it isn't capable of contemplating every single thing that can come up. And so it tends to make broad grants of authority, and sometimes you have to imply the existence of things that aren't written explicitly. The argument here is that based on these cases and the legislative grant, the existence of jurisdiction for this board to consider its own abatement orders and not just to turn them over to someone else has to be implied.
All right. Okay, thank you, Mr. Chairman.
Doctor?
Mr. Wong, the issue was brought up about context by the respondent, and I wonder, and you avoided that, discussing it, because when you spoke next, you talked about the broad authority which abrogated this whole thing. I want you to specifically comment to me as a layperson about context, because you always take things in context. That's why you have paragraphs and sentences. So please help me out.
Certainly, Dr. Lerner. The context actually in this case, and responding briefly to Senator Holden, is that the case that they cited talks essentially about the exercise of powers expressly granted to the body. If you look to the authorities expressly granted to this hearing board over appeals, as I said, you find only 3 provisions. The legislature, if it wanted the hearing board to have appeals over every district determination, would have said so. Instead, they said, well, you have the ability to hear appeals over 3 specific matters: permit issuances, permit denials, and ERC refusals. That's it. They did not say, oh, and by the way, you have powers over other things. They didn't say that. It expressly limited that authority, and therefore that is the context you have to examine. You have to look at the powers expressly granted to this body. You cannot make up powers.
Respond to that. You're still not answering my point, and maybe my point is too simple, not worthy of an answer, but there's a paragraph in which that sentence, the words may be appealed. That's the context. We weren't, when this stipulated order was created and we all approved of it, we didn't think about that. We thought in the context of that, which may be appealed, because that was definitely put in there for a reason. And I want you to answer the question specifically about this.
About that
because
particular language, okay.
Let me just continue the thought, because if you felt that way at that moment, and you had an opportunity to read this, I mean, it was presented to us, within a day or two of the actual hearing board meeting, you had an opportunity to say, gee, that's not right. That gives them too much authority. Please comment.
Yes, and again, the language that you refer to does not say may be appealed at hearing board, so there's really no notice. I know you're trying to say that we should imply that, But as Ms. Bird also indicated, she did not understand that to be the meaning. So it is not clear, and therefore the district had no reason to object to that because it was not clear. And as the circumstances point out, the appeal to the courts is much more expeditious and certainly a much better form of relief than the hearing board.
May I come back to that?
Certainly.
Again, you had knowledge of this. And the context is there. It's not about appeal to whom. It's appeal to the board. It was clearly made to appeal to the board. Because I remember that sentence, and I remember a couple of other things. I haven't looked at the web telecast of this, but I am convinced myself that we were talking about we were going to get it. And if you really felt differently, that was the time to speak up and say, gee, this isn't good.
Dr. Lerner, I do think it's a little bit unfair to impose on the district an obligation to object to a clause that doesn't exist. Secondly, as I indicated, even if we did agree, parties cannot stipulate to give the hearing board authority over what they do not have. So if it was to the hearing board, the district cannot stipulate to that because lawfully that is not allowed.
May I speak to this
Briefly,
question?
please.
Two things in terms of context. Unless you are talking about an appeal to this hearings board, that clause has no business being in the order because it's not an appeal to court and you wouldn't need to state it. If there's no administrative rights, we can go to court whenever we want to. So it's surplusage. It's another rule of statutory construction. You don't read words as being surplusage. Second, to tie this into the whole discussion about, did we want our results considered or their results, and you come to a compromise, which is the district has to consider our evidence, and then you have the clause, but that can be appealed. That can only mean one thing, that this board recognized there could be difference in the data, and if there were disputes about that, they wanted that dispute brought to you for determination. And it's not necessarily an appeal, that's just the word that was used. But that the focus on appeals, in my view, is semantics that is important only to the extent that it tells you we're not talking about going to court.
Ms. Prusek,
I have no questions. I'm ready for deliberation when we are.
as am I. Senator?
Right. Mr. Wong, did the board have the authority to adopt stipulated order of abatement conditions? Do you have the authority, this board?
Oh, you're asking if the board had authority to issue the stipulated order for
And in
abatement?
that stipulated order, they talked about sampling or testing for excessive emission, is that correct?
I believe so, yes.
Okay. And they also set terms and conditions for which they consider excessive emission to have been discovered, is that correct?
I'm sorry, to discover.
The time, after a certain number of days, certain number of tests, repeatedly, then they say, well, that's excessive emission, is exceed 1.1 nanograms.
Well,
That's in the stipulated order.
well, the order talks about monitored readings, not necessarily sampling and testing.
Oh, that's what you have to do. You have to have sampling to determine whether or not it's excessive.
Right, so if that's what you're referring to, the order does refer to a 3-sample average that if it exceeds 1.0 nanograms per cubic meter of hex chrome.
That's correct, right?
That is correct.
Okay. So find when that occurs and they exceed the limit, and the district determined that that's been exceeded, and they say we also permitted them to have their own testing procedure, and we were stipulated that the method that they use for testing is okay, because the methodology that they use to test is to be signed off and approved by the district.
Actually, that gets to the merits. There is a question about whether the testing results were done pursuant to a sampling analysis plan.
No, I'm not going astray right there. I'm just nailing him on this one. Not nailing him, trying to get to the point. My point is, therefore, when there's a dispute between what the district discovered in terms of excessive emission and what the respondents have determined excessive emission, then who's to hear that dispute?
Well, again, no one hears the dispute. The district gets to consider their evidence and decide based upon its own monitor readings.
So this district decide who's right or wrong in that case in terms of,
That is what the stipulated order provides for.
but the district decides?
That is correct.
And then if there's a disagreement, then what happens at that point?
They can go to court.
And the court will decide who's right or wrong?
The court can make that decision. But again, the issue is not who is right or wrong. The question is whether the district considered their evidence, which the district did.
But the court has already stated that you have to exhaust the administrative remedies, which is administrative, before the court will hear the case.
Well, the court did not state that. It is a requirement of state law that before you seek relief in the courts, you must exhaust administrative remedies. They did not do that in this case simply because they filed an appeal and did not wait for the hearing board to make a decision. They just went ahead and filed a lawsuit and sought ex parte relief. So they basically assumed, and the court assumed, that there was no administrative relief to exhaust.
They're here today seeking administrative relief so they can be in compliance with the court.
And that is a problem because they've already gotten a decision from the court.
But henceforth, and for the case that the court has not heard, they're here seeking administrative remedies.
They are not. As they have indicated, they are only seeking administrative relief for the February curtailment.
Doctor?
Last question. It was my understanding at the meeting, the board, when the stipulated order was approved, that we were going to, everybody agreed that, that the respondent could have their own monitors, but those monitors had to be approved by the district. Is that correct?
Yes, and they were not approved.
May I speak to that?
Very briefly.
If we are allowed to proceed, we will show you that what Mr. Wong just told you is not true. We submitted our final plan for monitoring on February 8th. The district had 7 days, according to the order, and 3 options. They could approve it, they could conditionally approve it, they could reject it. Within that 7 days, they did neither.
Okay.
8 days afterwards, they sent us some questions. So if there is not a plan in place, it is because the district has, in this instance also, failed to comply with the order of abatement.
Okay, thank you. Doctor, the issue is, do we have the authority to hear it? Not whether,
But it goes back and forth, I'm sorry. It goes back and forth, and it was implied, and I'm sorry for exceeding what we should have, but this is an important issue for me because okay. Thank you.
I think it's important to all of us, but we're not at that point yet, or I don't know if we will be at that point. Ms. Prusek? Okay. I think at this point, we need to hear some closing arguments from the parties and then deliberate. Pardon?
I think they already argued.
Yeah.
I think they've already argued.
They have, I think. You want to hear a summary statement from the parties, or you want to go to deliberation?
The district is willing to waive closing argument.
Okay, all right.
So will respondents.
Let's go to deliberation then. Ms. Prusek.
I'm happy to begin because a lot of arguments were made, a lot of things were said, myself included, probably all of us sort of led the parties a bit astray on the arguments because I think we have a very straightforward and simple question to answer. And the only question that we have to answer is a legal one, and that is whether we have jurisdiction over this type of appeal that has been brought before us, and whether somehow we've been given that jurisdiction. And I just want to start with the basic premise that we always start with, which is the Health and Safety Code. And we have always operated under the premise that the Health and Safety Code created this board, and the Health and Safety Code defines the authority and jurisdiction of this board. And there is no other jurisdiction outside of what has been given to us as a board under the Health and Safety Code. And then the other premise, which is the legal argument, which I agree with, and Mr. Drucker's actually agreed with as well, which is if there is no jurisdiction that is given to us, we cannot create it ourselves. We cannot consent to it. The parties can't stipulate to it. It can't have been given to us in order for abatement, with the party saying, even though there's no jurisdiction, you may have it. So the question is, do we have jurisdiction? And I think the answer is no. And the reason why is because I have not, and I think Ms. Bird did a great job of trying to really pin down Aircraft, Mr. Duckers, about where is this grant of jurisdiction? And the answer is it doesn't exist. And let's just step back a second and say if there was no stipulated order for abatement and a party tried to file an appeal with regard to this type of decision, a decision where the district was considering monitoring data and rejected it, would we ever take that appeal? And the answer is no, because there would be no right under the Health and Safety Code. The few provisions that were cited to us include 40501, the Health and Safety Code, and as Ms. Bird drew out in questioning and points out, that is not general to all of the hearing board's powers. Rather, that is very specific to the Article 7 in which it is found, which has to do with variances and permits. Also, as the district has pointed out, Mr. Wong has pointed out, we do have the right to hear appeals, but they are very limited, and they're only of three natures. And if you look at any one of those provisions, it's very clear that, for example, in 40713, with regard to ERCs, it's specific. It says within 30 days after receipt of the notice of refusal, you can request the hearing board of the district to hold a hearing on whether the application was properly refused. And we consider that to be an appeal. And it is like that with regard to permit denials and with regard to the granting of conditions of a permit to which parties disagree. The only other section or provisions of either the Health and Safety Code or the district rules that was pointed to was rescinded because it has to do with orders for abatement and a specific finding, and the argument that we cannot delegate a necessary finding, which would be true, except this was a stipulated order, and under 806B, the findings in paragraph A, including the order of abatement results in a closing or elimination of an otherwise lawful business, etc., does not need to be made in that situation. So I don't see any specific grant of authority for us to have jurisdiction. It cannot be thus allowed just because the party stipulated to it and this board consented to it. Also, I think it is very unclear, obviously, who the appeal is to. Regardless of whether the word appeal is used or some other word is used, it still does not say who it may be appealed to. And I think the argument of estoppel, I understand that there are two different matters, and one was the February 14th closure, and another was a different one, March 2nd, I believe. It is the same issue. And it's the issue, and I understand that the administrative remedies maybe still are yet to be exhausted in the February 14th. But when Aerocraft went to court and argued that it should have a temporary restraining order from the Superior Court with regard to a different closure, but still the same portion of the stipulated order, it implicitly said that it exhausted its remedies and essentially said it was otherwise futile not to do so, and I have to agree. And that goes back to the idea of what was meant by, I agree with Ms. Byrd, I did not walk away with the understanding that this board would hear appeals every time there was a disagreement as to consideration. But it is futile for any appropriate relief to be sought from this board with regard to that provision, because that provision has to do with the immediacy of a closure. And this board can never, ever hear a case with that much immediacy. We do not have the right to have an ex parte appeal of that nature. And so as a result, there's never relief that can be granted. And it is futile to come before this board. And I think those are all the arguments that I heard made, but I don't believe we have jurisdiction for all those reasons.
Anyone else? Ms. Byrd?
As the questions I was asking may have led you to believe, I don't believe that we have jurisdiction either, based on what was presented. I think it may be that we might, even, and I'll make the statement, this is really to the board, even if it seems or appears that we should have jurisdiction or we should see this, or even if for whatever reason the order was written and there's language that might be confusing, at the end of the day, we have to base it on something. And as Ms. Prusak said, it would have to come from the Health and Safety Code where our authority lies, and it really, it can't be found there. So I'm definitely in agreement that we don't have jurisdiction.
Any other? Ms. Prusak?
I had one other point, and that was there was an argument made that we retained jurisdiction in the order. And that's true. We do always retain jurisdiction over our orders. But often there are issues that are, while we still retain jurisdiction over the order as a whole, there are issues that are appropriate for a superior court to make a decision on. And we still retain jurisdiction, but not necessarily over that issue. And we recently had that you mentioned, Chairman, the SoCalGas case. And there was an issue of interpretation of the meaning of some words of our order. And we did not have the final say on that. And while we retained jurisdiction over the entire order, it was still able to be argued to Superior Court what the interpretation was. So that I don't see an inherent disconnect with that.
Senator?
I go back to the implied statement and back to page 4. And if you look at line 11 of the respondents, it talks about the power that's granted to the board by the Health and Safety Code 42451. Going to talks about why the powers are granted to limit the discharge of air contaminants into the air upon the terms and conditions set forth in the stipulation, Health and Safety Code 42451, etc. Recognize the hearing board's jurisdiction to issue, modify, revoke, abatement orders, permits, or variances. The board has all power necessary to carry out its order. And they say that the authority is implied or implied and from the power granted. The authority to do what you're seeking is implied that it can be done based on the power that's been granted. I say to you that if that's not the case, then we should move very quickly to clarify the law in Sacramento to avoid any ambiguities, number one. Number two, I'm concerned, disturbed, that the district having full knowledge what would subsequently occur in a case like this, even though both parties agreed to the stipulation. What was the intent of the board at that time? Was the intent and the belief of the board and or each attorney that the argument be made in terms of jurisdiction would come back to this board or go someplace else? If that's not the case, it seemed like to me the question should have been asked or raised by someone. What we do in a case when we do in fact appeal? It's almost like another case, what's reasonable? We can't incorporate in our decisions confusion. Our statements can be interpreted 1,000 different ways because we're going to find ourselves being ineffective, in my view, in not doing the job that we are charged to do in terms of cleaning up this air. I'm disturbed that the district, having foreknowledge that we could come to where we are today, because I depend on the district for legal advice, to come to where we are today and being at this point, not being able to make a decision. I'm not going to vote to support the district. I just, perhaps in this case, will abstain, and I would suggest to both parties that they seek a legislative remedy to clarify the point, so something like this never happen again.
Ms. Bruzak.
I agree with some of what you say, Senator. I do think it's very unfortunate that the order ended up being so vague. I do think it's unfortunate that the order ended up being so vague with regard to this appeal and who the appeal is to. And I have to say, usually I will catch such vague language, and this time I did not. And and we're in this situation, and I will hope that in the future we'll be able to clarify that kind of language. But be that as it may, I just wanted to point out what I see as an inherent difference between the frustration of having the ability to enforce our own orders versus what we're looking at today. And I agree that this board should always retain. We do retain jurisdiction, which means we retain the authority to be the final decision maker with regard to whether there has been a violation of particular conditions. So that's always the case where if we have a stipulated order or a regular order for abatement, and there is a provable violation, and we always have the right to hear that type of a case. So we do have authority to ensure enforcement over the conditions of our orders for abatement as well as our variances. But this is different, and the question is this vague language of maybe appealed and what was meant by that, and more importantly, whether even if we all agreed that it was this board that we all thought it was, which we don't, but even if we did, the question would still be whether or not we legally have the jurisdiction to hear it. And I don't see any jurisdiction granted.
It's my understanding that the words may be appealed were put in there and stipulated to by the parties at the request of a respondent, because respondent wanted to make sure that it was clear that there would be some relief if there was a disagreement. Consider, however, if those words weren't there, what would happen if there was a disagreement? It would be appealed to the court, not here. That's all. There's no further comment. I'll entertain a motion. Ms. Broussais.
Well, I'll make one, but I just want to make sure I know who's the moving party. I could look back, but
It is a little confusing. We did move to dismiss the appeal, so I guess we could be considered the moving party.
okay. why don't we do that then? In the case of South Coast Air Quality Management District versus Aerocraft Heat Treating Company, Inc., case number 6066-1, I move that we grant the district's request to dismiss the appeal brought by Aerocraft on the basis that this hearing board does not have jurisdiction to hear such an appeal.
Ms. Byrd,
I'll second.
discussion on the motion.
On the
Doctor, how do you
motion.
vote?
You said discussion.
Sorry.
I cannot support the motion. And the reason why is that don't want any action to be taken or implied that this board or this district will stall or cause it to stall any attempt to go forward to clean up the air in this area, get rid of chromium-6 in this community that has suffered for so many years. And it's my view at this point in time that this litigated action as relates to this agreement takes a lot of time and effort. As I also said before, unnecessary. If that statement had not, appeal statement had not been included in the stipulated order, and someone should have caught it, knowing that this would be the ultimate end or decision to come to this board and consume more of our time and so on. I think it's in poor taste, and I'm not going to vote for it.
Ms. Broussard.
I do need to ask, Senator, how do you think there is a stalling of enforcement of this order when the issue being appealed is that the order was actually enforced in such a way as to curtail operations 3 times? And the decision of this board is not to undo that enforcement, but rather merely to say this is not the tribunal or the venue with which an appeal can be heard by Aerocraft to that provision of the order.
It gives you, I'm a public member, it gives the impression to the public that I believe that would say, there they go again. They can't go forward and get things done right in a timely fashion. In my view, I'm telling you, okay? And that it does not negate the order, but it gives the impression that we are again have not finalized the order in a way that we can go forward and do the job that we are charged to do, and that is clean up the air, et cetera, et cetera. It means that we still it's evolving. It gives the impression to the public that it's evolving, and that's my point.
It's not about impressions, it's about the law.
I understand that very well with the lawyers, and that's why I'm going to, I suggest that you should go get a clarification of the law.
Ms. Broussard.
But again, I do not want to leave the public with any impression that this board is causing any kind of slowdown or stoppage in the process of enforcing this order for abatement. This order for abatement has moved forward. There is nothing stopping the enforcement. In fact, the enforcement continues to exist. The only issue before us today is whether if Aerocraft disagreed with the consideration or non-consideration by the district of opposing monitoring views and thus keeping it closed down is an issue that is appealable to this board or somewhere else. And we are merely saying that this board is not the appropriate jurisdiction, but it's not slowing enforcement. And I just don't want to leave anyone in the public thinking that enforcement is in any way being slowed down by the decision of this board or by the order as it stands.
Ms. Byrd.
I have to reiterate, well, I'm not going to reiterate. I agree with what Ms. Prusak said, and I think that while maybe the order itself did not include a word or two that may have clarified it, I think that for those of us voting, at least I know myself, and I know that Ms. Prusak has also said the same thing, an understanding of the hearing board's own restrictions or limitations went into my vote. So it's not a matter of I was expecting that they would do something different. I was expecting it based on what the limitations are already of this board, and knowing that the board could never have an ex parte appeal come through that would allow this facility to in any way be able to operate once the district said shut down. And that was the understanding of this member, and that is why it was voted upon. And perhaps it was not the understanding of every member, but it was the understanding of this member.
One final statement. To me, becoming a pattern where the board unintentionally incorporating certain terms in settlement agreements, they end up having a latitude, a wide range of interpretations. Reasonable is one, and the list goes on. And what really happens then is that we have to have a lengthy discussion and debate what we really intended to do at the time. When the legislature in this, we acting as a body like that, is what the intent at the time that you made the decision. Now, it's already been stated by Ms. Burden that the intent was that we would not allow an appeals to be heard in this case by this board. Fine. If that was the intent, that's the way they took the position that they took. And unless I interpreted you wrong.
No, I was just going to say, and that's based on already knowing the limitation of this board by this board member. That's saying that we could not issue an ex parte, we couldn't have an ex parte appeal. So why would, if that's not even possible, why would I think that that could be interpreted that way?
And the ex parte is not part of the
Well, that's kind of what, that's part of the brief, the explanation that they actually requested an ex parte appeal.
that was denied.
Exactly.
Denied. So that's not before us today. What's before us today?
No, what's in the brief is before us, and that's what
The
I'm
brief
stating.
is before us, but
Yes.
not the ex parte brief. The
Well,
petitioner made the brief, and that's the district.
Ms. Brissette.
I just think we're also mixing apples and oranges. I think that this board is a bit sensitive, having just recently had a case where we were not able to interpret our own order for abatement with regard to language such as reasonable. I think that's a question for a different day, and a very different question from what is before us today. This is not about whether the hearing board can interpret its own stipulated orders for abatement. That isn't the question before us. The question hinges only on whether we actually have the jurisdiction, because we can't interpret jurisdiction to ourselves. We are not allowed as a matter of law. And both parties agree that if jurisdiction isn't otherwise given to us, we cannot give it to ourselves through any kind of interpretation, nor can the parties stipulate to it. That is a matter of law. So it is a very different question as to how you interpret reasonableness, whether we have the right to interpret who the appeal is to. If this board doesn't have the power to have jurisdiction over the appeal, it doesn't, period, matter of law. It doesn't matter how we interpreted it or what our intentions were in the very first instance.
Chairman, finally, did any member of the board at the time they adopted this order, which included appeal, have the understanding that what problem that would be caused if the issue was raised is to whom do you appeal? And if that's not the case, then it's a cloud. That's the point I'm only making.
Even if the words "may be appealed" were not in the order, who knows? Aircraft may still be here trying to appeal the decision of the district. So I don't think that might have added some confusion on the part of some people, but it doesn't change what the law is. Any further comment, discussion? Okay, now, Doctor, how do you vote?
In favor.
Senator?
Abstain.
I vote yes, motion passes 4-0, 1 abstention. Thank you.
Mr. Chairman, could I just, this would be very helpful to us. As I understand it, we've previously ruled we don't have a right to an ex parte appeal. You've now decided you don't have jurisdiction to hear an appeal notwithstanding the language of the order. Is it the board's understanding, as it is mine, that upon the issuance of a curtailment order, we have exhausted our administrative remedies, that there is no other administrative remedy before this board in light of this ruling?
Do you wish to respond?
On that issue, is that what you're saying? I think-
Yes.
Well, before I rule, or we rule, I'd like to hear from Mr.
Yeah,
Long.
just briefly, the board does have jurisdiction over other matters, so I'm not quite sure what they plan to file an appeal over, so it really depends on what they want to appeal.
So you see the dilemma, I'm sure, that we have here, which is we have an order that says it's appealable. The order appears to suggest it's appealable to the hearing board. If that's why we've dealt here first, we run into the doctrine in court of the exhaustion of administrative remedies. I think you've decided here today that at least on this issue, we have no administrative remedies after the order of curtailment is issued, and I just today I seek to have that confirmed. I believe we're back here next week on the 16th to talk about modifications to the order, and obviously one of the things we're going to want to take out is the word appealable because of the uncertainty that creates.
May I just say that this board is not in a position, nor would we want to make any kind of ruling that is not before us today. So to make a blanket ruling that in some appeal that may be filed, that remedies have been exhausted is not something that we can do. What we can say is that we did rule that we do not have jurisdiction over this particular issue that was brought to us today, and that can be argued to the court in terms of futility.
It's my opinion, if you could sit there for a second, that the court, you heard what happened today, and that you requested from this board the intent as to whether or not the administrative hearing request had been exhausted. And I'm of the understanding that if we say yes, then you would appeal to the court and say, well, I exhausted my administrative.
Senator, they've actually already filed a lawsuit, so they don't have to file another one.
Yes, I understand that. And when the court asks whether or not, when you go before the court and say they have not exhausted their administrative hearings, then they can say, yes, we have, or no, we haven't. And I think that's the reason why the question has been raised. And the record will show what we have done, and you just have to go on the record. But henceforth, we want to enforce this order. You understand that?
I do understand that, Senator. Thank you. One question that I have, as I've mentioned, we're back here on the 16th to talk about, as part of the abatement order, potential modifications to the order. A lot of those modifications are going to deal with the issue we just talked about. It's not an appeal, but it's rather, we're going to be seeking modifications of the order to require actual consideration, timely production of data, and things of that nature. We have improvements to the monitoring system. We have our witnesses here today who could be helpful to the court and understand, or to the board, in understanding the changes we're going to request next week. We can make them available today if the court or the board chooses, or we can bring them back on the 16th. I just wanted to make that offer, Mr. Chairman.
Appreciate that. Ms. Broussard?
We are not noticed today for modification hearing, and so we could not hear that under the Brown Act.
Okay.
Thank you. With that, Mr. Wong, would you prepare the form of the findings in this matter?
Certainly.
Thank you. We'll take a recess and reconvene at 11:20 and take up the hearing board's general meeting.
Do you have another question? I saw you going like this.
Could I just have 1 minute to check with my client before we wrap up?
Sure, we're off the record.
Thank you.
Okay.
We're back on the record.
Thank you, Mr. Chairman. We have nothing further, and we thank the board very much for your consideration.
Welcome.
We thank the board. Thank you.
Okay, 11:25. We'll reconvene at that time.
Then are we going to
Okay, this is the hearing board's general meeting. Today is March 9th, 2017. And we're in the hearing room at SCAQMD headquarters. We have two matters on our agenda today. The first one is with regard to scheduling policy. This is a matter that's been carried over since January. And then the second one is a matter regarding contacting individuals who have requested notification on high-profile cases. We'll take the first one on scheduling policy. Ms. Prusek?
What I provided is a very simplistic, maybe too simplistic, completely open to thoughts from everyone else, but we'll recall at the last board meeting, we were trying to incorporate the idea of limiting the days on which we have hearings whenever possible, so that we're not coming in for a 15-minute consent item on one day, and the next day one case, and the next day one case, if they could be consolidated on one day of the week. But as we realized, as the discussion went on and more issues were raised, there were just too many factors or circumstances that something so simplistic could not, we weren't providing for or considering, and it made me realize that there are probably even more that nobody had even thought of up to that point. So at that time, we thought maybe it would be a good idea to take out everything that was being considered with regard to if it's this kind of case, then it'll be heard in this amount of time, and maybe on a Tuesday or a Thursday or a Wednesday, and instead just try to encapsulate it by saying something, and this is the wording that I thought of, which is whenever possible, and taking into account noticing requirements and other important case management factors, which I think is sort of the catch-all for everything. Could be that it's an emergency, could be that others are not available, or it's high profile and needs to be heard in the community, or any of the many things that were raised and brought up. The clerk shall schedule cases with a preference being heard on a Wednesday first until any particular Wednesday's schedule is full, and then on a Thursday. And I use the word full because we also had a discussion about how many cases we think we could hear on a particular day, and rather than limiting that, I thought it would be really just a call based on the kinds of cases that are scheduled, because as we all know, a case can take anything from 15 minutes if it's a consent matter that's really straightforward, to days and days and days and days if it's a complicated matter, and it just depends upon what kind of case. And rather than assuming that, I just thought we'd use the word full, and it can be determined at the time by the clerks. Full, schedule is full. And it can be determined by the clerks, and if the clerks have questions, in consultation with members of the board, et cetera.
Thank you. I think that does the job that was intended. And I agree with the use of the word full. The clerk's office has good feel usually for how long certain matters are going to take, except for the high-profile cases. And I can't remember a time when we had so many on one day that we ran out of time to hear all of the cases scheduled for that day, which speaks to the I don't know, capacity or ability of the clerk's office, with some consultation with the chair, to identify just about how long it normally will take to hear the cases that are scheduled for that day. I think this gets the job done as far as identifying a day on which you start to, for an empty week, where you start to fill it. And it also takes into consideration the requirements of notifications that are required by law, and the fact that it does not interfere with the requirement that we hear emergencies and interim variances as quickly as possible. Any other thoughts? Senator?
I see the alternates who are not here. Were they notified about this?
Yes. They're not required to come.
I'm sorry, say that
They're
again?
not required to come. It's not part of the training.
I understand.
But
They were
I believe the alternates were notified.
fine, because they're usually here, some of them.
Yeah.
Okay. Now, my next question is that I understand what Ms. Prusak stated, but I don't know how it's going to be incorporated in the language which currently exists. In what way are you amending the language that currently exists as it applies to this new concept? What I'd like to see is a mock-up of what she said extemporaneously and have it included in those other directives as it exists.
This does not change the procedures that are in the procedures manual. It simply states a preference of the board on which date to place the first case for a given week. And in fact, it follows a practice that had existed here for quite some time, and where the council's office some years ago told us that they would prefer to have the first hearing scheduled not on a Tuesday, and the reason is that because they've been out of the office Saturday, Sunday, Monday, they've got some extra work to do on Tuesdays that they don't normally have, I guess, on the other days, and preferred to have their first case on a Wednesday. And so we did that for quite a number of years. And while we were doing that, the procedures that exist now in the procedures manual were in effect. And so this just goes back to that and doesn't change anything in the procedures manual. So there's nothing to mark up.
I would say to you that when we first discussed this issue, the procedures manual, you initiated some language on your own.
I did.
And that language you submitted for our comments.
I did.
And I just wanted to, I did clarify some of that so people wouldn't get the impression that it was self-serving.
Those were good comments.
Yeah, so it would not be self-serving and that it was designed for their participation and their notification as well, and as well as ours. And the clerk would have an idea going forward, what would be considered when she calendar an event, a hearing. So do me a favor, please, and will you read that, what your statement says again? Did you write it out or did you just talk it?
It is attached, I don't know if you received what's in your box today, but it's was attached to the board general meeting agenda. And so it is written out, and I'll read it though. It says, whenever possible, taking into account noticing requirements and other important case management factors, the clerk shall schedule cases with a preference for being heard on a Wednesday first until any particular Wednesday's schedule is full, and then on a Thursday. And the only intention here is to allow that to occur. So the clerk, if there's an empty week and the clerk's office is scheduling a case that has been duly noticed, and there's no other important reasons why it needs to be heard sooner or later or anything, this allows for that. And if there is no other issues, then it will be scheduled on a Wednesday until the Wednesdays are full.
Okay, it's clear.
Ms. Byrd?
I think maybe once this has been placed, wherever it's been placed, Senator, that we should have a copy, if that sounds like what you'd like to see it in place. And then the only other comment I had was because I went to my box, I think, too early, so I don't have that, is the word full. Are there quotation marks around it? Or just Oh, okay, it's not, okay. That would, and that's not absolutely necessary, but I guess that, the word full just makes me think, what is exactly full? And so I would put quotations marks.
Well, I would think that, though, in this context, if we were to quotate full, then it would assume that full came from some other place and is being quoted and has other meaning. And I think the intent of this is to allow discretion to the clerks to do their job, and they know how to do their job in terms of case management and all of that.
Okay. That was just a suggestion. It's not a requirement. It's not one of those words. There's so many words, that's what was mentioned earlier, that can have so many meanings, I guess. Okay.
I think that's right. And if this were in a stipulated order, for example, I don't think we would ever allow the word full to stand as this. But this is a very benign addition that just tries to make our judicial economy better in terms of how many days we're all coming in and wasting emissions when we could maybe hear it all in one day, if everything else aligns, and leaves very wide discretion to the clerk to do that.
Mr. Tether, I think, would like to address the board.
I appreciate it. I have only a procedural question. We would like to be sure that we have time on the 16th, or find out if it will fit the board schedule for our witnesses, which might take 2 or 3.
We heard what? What do you mean?
I'm sorry, next Thursday, we're here with the same group, and we just want
Is there anything else on the agenda? Yeah.
to put our witnesses.
We have just one thing on the agenda, and we'll keep the agenda, we'll keep it that way for the entire day. We won't schedule anything else, just to make sure that, yeah.
Well,
If I may say off the record or whatever, I didn't mean to mislead the hearing board with my assertion about Rule 806. It was perhaps an over-optimistic reading.
We understand.
Thank you.
I don't think any of us thought that,
I did.
except that one.
I've already apologized to you by a letter. Thank you.
All right, good to see you, my friend.
Yeah, okay, let's keep that day open for that.
That day, that's full. That's full.
Yeah. It may be more than full.
So,
All right, any other comments on that item?
any particular Wednesday schedule is full. What's the definition? I understand your point. Here's what's going to happen. If you get a number of cases, some of 5 minutes, 10 minutes, 15 minutes, then the clerk will make a decision based on the history, just how long it's going to go, or should she check with you? And I'm not
And they
saying
do.
she should
And they do where,
check with you to see whether or not this is going to go on.
yeah.
Would it be more
And
than
as I said, when was the last time that we ran out of time because there were too many cases on one day?
the last time we were here?
Because there were too many cases on one day? No,
One case can go over
I know.
2 other days, but that can't be helped. But meaning there are 5 cases on calendar and we never get to one of them. That's never happened.
And I've been here almost a year, about 9 months. And you should know by now, every time they ask me a question, I'm gonna give you an answer, right or wrong.
with a smile. Okay.
Smile more around here.
I'll entertain a motion to adopt policy. Ms. Byrd?
I move that we adopt the scheduling policy as indicated by the attachment that was received today with the agenda for general hearing.
I will second that. Is there any discussion on the motion?
Jokes aside, I think Ms. Prusak should define full really in the adoption of.
I would not want to do that, and here's why. There is no way to anticipate in writing in advance what full could mean, because there's so many permutations of the kinds of cases we could hear.
Okay.
We could have 10 consent matters,
All right.
or we could have 1 appeal. It just depends.
You're right. Then in that case, fully be determined by the chairman at the time that the clerk. I would think that then you would know those cases and just estimate the amount of time it's going to take.
It's a joint effort between the clerk of the board and the chair. Generally, the clerk of the board knows so well how long they're likely to take that they don't necessarily come to me. It's only on unusual situations that they come to me.
Let's modify it then. Full will be determined by the clerk of the board, the intent of the clerk of the board, and the chair and the chairman when necessary.
I think when you read this and the procedures in the procedures manual, that's sufficient. And I don't want to get too much in the
Okay, all right.
detail of the work of the clerk of the board.
All right, all right.
Any other comments on the motion? Okay, Doctor, how do you vote?
In favor?
Ms. Prusek,
Yes.
the author, and Senator?
From abstain to aye.
Okay. He's,
He says yes.
the clerk maintains all of the policies that this board has adopted, and so that's where this document will reside. Second item is Ms. Bird's. You all know we had some people concerned about a item that came on the agenda that some people felt that they weren't notified. And I'll turn it over to Ms. Bird.
I'm just going to begin this today. It will probably take a little while because technically the clerks don't work for us. We don't tell the district how to do things. We're in a sometimes awkward position of trying to request or get information. And I've been asking around somewhat to come up with some method that we could adopt, not knowing what part the clerks will play, what part we might play. But as was mentioned, there were some individuals who had been following a case and they were not informed until it was really too late for them to respond that we would be hearing that case. And that concerned me, and I believe it concerned others on the board. So I have started the process. I've talked with Denise, and I will have a continuing dialogue with Denise, but I wanted to maybe get input from the other board members as to any suggestions that they might have, how to approach it. I am only looking, just so you know, at high-profile cases, not just any case. But if you have any suggestions of things that I can inquire about further, I'd appreciate it.
Ms. Prusek.
I'm glad you raised this issue at this board meeting because it's been kind of floating in my head, but in a little bit of a different way. I think the problem that occurred with the case you're talking about is the problem of required notice in the Health and Safety Code and its sufficiency or deficiency, because notice was given, but it was the notice that's always required. I don't remember if it was posted notice, which nobody is going to read, or it's in a general publication of general circulation or whatever, which most people don't read and aren't looking out for. So I agree that the issue, once a case has already begun, I think it's very important to raise the issue of once people are on that list, we need to have a mechanism to make sure that they are continuing to get all the notification, even if it's slightly of a different kind that was re-noticed, but not a continuation of the same hearing. But I have noticed that it's raised issues for me, and when we say the word high profile, I think that also leads me to an area that I think is problematic, which is which cases are considered high profile. Well, sometimes it has nothing to do with emissions and the impact upon somebody's health. It has only to do with how squeaky the wheel has been, and a lot of times that leads to EJ considerations that are not being addressed. So we have had at least 2 cases I can think of, or remember, I won't name which they are, where there was a significant impact on an EJ community or more, where there was no special notice and it wasn't considered to be a high-profile case. And so no one showed up, even though sufficient notice under the Health and Safety Code had been given. And it leads to a disparity in some ways, and also I just think there should be some consideration, and I'm not sure, maybe it's with discussions, as you're saying, to begin with the clerk and see where we could insert ourselves. But perhaps the Health and Safety Code says what the basic notice that is required, but maybe more is required. And maybe we need a threshold if there's a likelihood of high emissions impact in a community.
Okay, so your recommendation or your concerns would be where there's high emissions. When I think of high profile and notification, I'm glad you brought that up because I hadn't gone there. I was more concerned with those individuals who would come in and will say, I hadn't gotten notice, even though I've requested to be notified every time there's a hearing. And you're right, there are cases where there's an impact, a significant impact, where we don't get anyone requesting any information. And that is another area that we've got to look at, because that's really important.
And when you look at what did happen in that case, that extremely high-profile case where we get turnouts all the time, to see the scrambling that was occurring and the difference in the turnout and the complaints about the turnout based upon the actual notice, it really highlights how deficient that notice is. Because if you're in a community where they're really attuned to it and they're looking for it and they miss that notice, then what's a community that isn't looking for it because they're so busy being burdened with other things to do? So
It's fairly easy to define a high-profile case. To me, that's a case where the public, there's a lot of people in the public that are concerned and have voiced concern. But there's other cases where public should be concerned, but doesn't know because of the nature of the notices that there is something there that they should be concerned about. In addition, on the other side, there are cases that public gets concerned about where the emissions are, there's either no emissions or the emissions are so low or so distant from any populated areas that I wouldn't call that a high-profile case. Perhaps we need some discussion with those individuals in the district staff who are involved with the community and can help us formulate a way to decide which cases deserve a notification beyond that which is legally required, and which cases are those which the public might be concerned about enough that they would be notified. We had a case not a couple of weeks ago where the clerk's office and I were very concerned about whether or not there was sufficient capacity here for the expected crowd. And I was concerned that we hadn't made arrangements for overflow. It turned out that those who in the district staff who are close to the community on a regular basis, they knew we weren't going to get too many people here, and that's the way it turned out. So I think there needs to be a dialogue with those folks in the district staff who are close to the community, who can help decide when and how those notifications should be made beyond the legally required notifications. Ms. Broussard?
Are you suggesting that we come up with a rule of thumb in advance, not case by case, right? We wouldn't go poll on a particular case, poll the district, should notice be made in this case? I assume you mean a rule of thumb based upon emissions or proximity to the source or type of pollutant, that type of thing?
I'm not really sure, but the thing that immediately comes to mind is some kind of review of the cases, of the petitions by the district staff, not the clerk of the board, but district staff who is close to the community, so that they can identify what needs to be notified, what extra steps are needed for notification.
I worry that if we leave it case to case, then we lose our independence because there's always, the district is always on one side or the other and always has a position, and it would not address the main issue that that Ms. Bird brought this before us, which is a case where it had been identified as high profile, yet for the hearing that we held recently, that notice was not given.
What independence are you talking about? You say lose our independence. What?
I think if we allow one party to determine, I think it's smart to go to the district and ask what set of circumstances should we be looking for in order, if we can, increase the notice, and if we decide there's a vehicle by which we can for the cases that we identify, to have them help us identify them by saying these are the factors you need to look at. It should be, this amount of emissions or threshold amount of emissions or a proximity or a type of pollutant. These are the toxic ones, et cetera, But to have the district go through each particular case and determine for itself where it notices and where it does not notice, I think could be problematic.
I'll just throw out what I was thinking, just in talking to Denise last week. I was thinking that if one of, and I would be willing to do this, if one of us monitored as cases were put on calendar, the various cases, then when they are put on calendar or when we know they will be held, we could contact Public Affairs directly and just mention to them that we have a concern for a particular case, and just to see if it's something that they can do, because we can't tell them what to do, but to tell them what our concern is regarding that case, and to perhaps get feedback from them as to whether or not they can facilitate something happening, or if they can't, just letting us know that it won't happen and why, because we don't really have the ability to have them do anything. And I was also under the impression, and I can't recall where I heard this, I may have, maybe from listening to a governing board meeting or something, that the district itself is under some efforts to get communications better within the district. So maybe this is a good time to bring this up. I'm not sure, but I can check on that. But that's kind of my feelings. As it comes in, even if it means that when I see it, I send an email to, or when we come in, to say, hey, does this look like we should move on this? And if we agree, then we can let the Public Affairs, we can contact Public Affairs to find out what they have in mind and make suggestions from that point.
Ms. Diaz has been around a while. You have any comment? Nope.
I know, well, you guys also get phone calls, so should, and I don't want to base it just on the phone call, or we could technically base it on the phone calls that come. Yeah. And we want those, but we also want those where there's not a lot of people who have been showing up, to make sure that even though they get what is considered the legal notice, that they also have some idea. Like, there are some communities that are impacted, and we sit here and we wonder why there's nobody here. And that concerns me. I know it's come up. It concerns some of the other board members as well. And we don't really know what to do with that.
We've had some high-profile cases where members of the public who show up for a hearing tell us, this has been going on for a long time. We didn't know we could complain to the district. We didn't know the district existed. Some better notification would have perhaps shortened the period of time that they were exposed to the problem. Ms. Prusate.
I wondered, I know we cannot advocate for or request a legislative change, but perhaps consider who could and advocate to that body, because I've long felt that the required notice that's been on the books for a very long time is antiquated and no longer relevant in this world, and that's why people don't show up. And I also feel almost silly, and I shouldn't be saying that, how many cases we hear, either an interim variance or an emergency variance, where we're sitting there and really upholding the right of the public to know, knowing that no one will come to the hearing, no matter what we do. And I do believe it has to do with the deficiency of notice that is required. And so either if it's not something that we can try to have public affairs do, maybe we can advocate for the governing board to seek a legislative fix to that and require better notice or more effective notice. I don't know if that's something you've discussed with the clerk.
Doctor?
We had one case recently, which I think we saw on Tuesday, then we saw on Thursday. And it was just 2 days apart, or maybe it was Thursday and the following Tuesday. But some of the people in the audience complained that there was not sufficient notification. And I think you responded, Julie, and said, once there's notice for a meeting or a hearing, that the subsequent ones were not necessarily noticed. And that was the one that struck me. It was the first time I've ever come across that. I obviously am not around long enough to appreciate exactly what's been going on. But that continuation thing where we were able to resolve it that next time, not enough people were here that I think wanted to be here, and they were annoyed about that.
I think that, this is a regular practice that we have. So if you can't finish a case, you need to move it to another day. But the notice if the notice is sufficient to get people to that first meeting, which it was, then the idea is it's being webcast, people can come, they've already been noticed that hearing is happening. So if the continuation is then announced by the end of that hearing day, that people have received sufficient notice.
I agree with you, everything you said. I'm just telling you that the feedback actually was directed to the board at the end of that meeting, and that's how you responded. Don't get me wrong, I think your response was perfect, but it just represented their frustration.
Yeah, and I think it's, as Ms. Burr was pointing out, I think it's the frustration with the initial notice not being the same as they've been receiving.
I was looking at our agenda and wondering, I was looking at the audience, and there's nobody here from Public Affairs. And so I looked on the backside of the agenda. I don't believe that Public Affairs receives a copy of the agenda, do they? It's not shown on the back on the list of people who receive it. Okay. Perhaps we should invite Public Affairs to our next general meeting to further discuss this and see what thoughts that they might have to do a better job of notifying the public. What we do satisfies the law, but as Ms. Prusak points out, and Ms. Byrd, it's insufficient in many cases, and we need to do a better job. So
we can continue the discussion to next board meeting and get someone from Public Affairs maybe to come.
I will take it upon myself to send a note to Public Affairs, inviting them to the next general meeting, telling them what it's about.
That's all I have.
Senator?
In the eyes of the public member, these kind of words of deflection, Ms. Byrd has hit a nail on the head, and the public's got a right to know timely. And I don't know what the legal notice is. Maybe somebody explain to me what's the legal requirement?
Well, I don't have it in front of me, but the legal requirement is, it depends upon what kind of case you're talking about.
Any case.
Well, no, they're different. So if it's a short variance, for example, only 10 days posted notice is required. That means outside this room, posted up on the agenda. And it also gets put on the hearing board calendar as well. So we actually do provide more notice for those who follow the agenda of the hearing board. For regular variances, it's a 30-day notice in a paper of general circulation. So it's just put in some section of a newspaper. 30 days.
Okay.
If you'll go to tab 7 on your reference menu.
I saw that, yeah.
It's got that. And then the clerk of the board deals with, I believe, companies that have identified for each geographical area what newspapers are appropriate that satisfy the requirements of the law. And those are the papers that...
I just wanted to state it for the record. I understand what you're saying. The point's well made. As it for different variances that's being requested, the posting is different for each. I understand. I think Ms. Byrd raised the point appropriately for the record as we addressed the issue of the Aliso Canyon. At the very end, she made the statement, and that was viewed by the public, that we should give public notice. It was viewed on webcast. Okay, which is really something they like to have heard, that we're going to address the issue of public notice to the public in high-profile cases, but certainly was high profile for you and I, and in some communities may be high profile for an individual who feels personally affected by whatever emissions are being in their neighborhood at that particular time. I'd like to think maybe if we get the emails of people, addresses, who are concerned about what things that we do here, whether it's in their area or not, do an email blast saying, an email blast. Do we do that?
I think that can be done, but let me ask, Ms. Diaz, is there a list of people who want to be on the distribution list for the hearing board agendas?
Yes, hearing board agenda, no, we don't have a list for that.
Okay. But there's not a problem in doing that. Can be done,
Yeah, we can do an email blast and done.
yeah,
And
right, but what the senator's talking about is something that not that you have to go look for it all the time, but that it comes to you automatically. Amen, yeah.
right, because I know some friends of mine and people that I know go to the website for the district and they can't find nothing. Okay? The expert, they go look at one area and they go look at another area, and by the time they come up with what they think the answer they're looking for, the matter's already been heard. So I think it's a good point that was raised. The discussion should continue, but if we can come up with an email blast to people who made a request for information about what we do here, go toward answering that question and solving the problem.
And Ms. Zara did mention that the district has a listserv, at least one that she knows of, so I'm sure that it may be possible to set that up. We'll know when public affairs comes, we could talk about that with them.
Publicize that on the website. Just add that to the website, that anybody who wants to be on the list for all agendas.
Make the request.
Yeah.
Submit your email address.
Mr. Chairman, is it written in law or in stone or by tradition that the notice times are fixed? How are they decided?
It's in the Health and Safety Code.
I'm sorry?
It's in the Health and Safety Code.
Gotcha. What if the board and the district and the respondent would like to meet sooner? Can't do that. The
Say
Health
that
and
again?
Safety Code does not permit that. In other words, you have to give notice, you have to wait a month before the thing is scheduled.
You have to wait the appropriate time, noticing requirement, depending on the kind of,
I understand that, But the longest one is 30 days, is that right?
actually 45 days, because
45 days?
you have to, there's a period of time to get the notice published. Once it's published, then the time starts. So if it's a 30-day notice requirement, and I go to the newspaper and I say, I want this published, and that takes a couple of days, the 30 days doesn't start until that notice hits the paper. That's when it starts.
This is too long.
Well, that depends. That's why, okay, if it's a regular variance, petitioner needs a variance, but needs a variance for a long period of time, more than 90 days, legislature says, you got to give the public 30 days notice, published. If it's a short variance, 10 days posted. But if it's a real emergency,
No, I understand.
okay. Now, there's another thing that's going on right now, which I think we've needed a long time, and that's orders for abatement. Order for abatement got to be published, it takes time to get here. If it's an order for abatement, the problem is such that the district has been trying to get this source into compliance, and the source is either unwilling or unable to comply. And the penalties they're paying haven't done the trick. And so that's when the district comes to us with an order for abatement. Now, if it's a really urgent thing, it still has to go through the normal noticing. What is being done now is that there's an effort to have some legislation to allow an order for abatement to come to us. For an order for abatement to be issued by on an emergency basis by the executive officer, followed by coming to the hearing board with proper notice for approval, I guess. So there's an effort to deal with that notification problem where there's an urgent emissions problem.
I thought that the detective officer did that in case of Torrance.
The authority does not now exist.
What?
The authority does not.
Well, he
now
had no
exist.
authority to do that?
What?
He had no authority to
He has authority to go to court.
well, I thought he had, what he did, publicly I understood, maybe he's requesting an order of abatement, maybe rather than issuing an order of abatement.
He can request an order for abatement, but the noticing period has to.
Okay, all right. Whatever needs to be done to fix the problem, we should do it. I have no problem with that.
Order for abatement is how many days post, list, 10
And that's published,
published.
so that takes,
That's great. It's the 30-day one that I'm troubled with.
well, in a 30-day, what's happening is that the source doesn't yet need an order for a variance. But if they do, they have the interim variance option that they can come in and ask for an interim variance to take care of the situation between now and the time that the regular variance can be heard. Okay.
All right.
Anything else?
Got a call for the question?
I don't know what the question is.
What is the question?
And I don't know what the answer is.
Okay. All right, here's what I think we've decided. Number one is that we're going to look into the establishment of a notification list by email of those people who want to be notified of of all the agendas of the board. And secondly, I will send a note to the Public Affairs Office inviting them to our next general meeting to further discuss the issue that Ms. Byrd has raised with about the insufficiency of the legally required notice process.
We're not on camera, are we?
Down there?
Oh, because I sat at my seat here,
Oh, that's a very good picture.
and I saw a picture of this young man at my desk.
You grew some hair. Very good.
He came to a meeting here
I thought it was Denzel Washington. He's a very handsome man.
at Diamond Bar City Council. They had their meetings here, City Council. And my grandson represents Supervisor Hahn,
Oh,
and came
That's your
here.
grandson?
He sat at my desk, and he said that to me. Funny as can be.
very good.
I'm not gone yet, grandson.
You will always be here. If there's any other business? Yeah? We are adjourned. Thank you.